This is The Chris Berry Show. Expert information on elder law, retirement, and estate planning. Information that you can understand. Here's your host, Chris Berry.
Welcome to The Chris Berry Show. I'm Chris Berry, where we talk legal, financial, and tax planning every Sunday at 2 p.m. on FM 101.5 AM 1400 The Patriots. So each week we talk about issues affecting planning for the second half of life. And if you have any questions or want us to read those questions and answer those questions on air, feel free to call us at any time. Leave your question at 810-355-2584. Or you can email us at any time by emailing askchris@thechrisberryshow.com. And you can visit us online at thechrisberryshow.com. So this week we have Memorial Day coming up. That's going to be tomorrow. So I thought it would be interesting to pull some facts about Memorial Day. First fact is talking about when actually Memorial Day started. And there's some confusion over when Memorial Day actually started. So shortly after the Civil War, both in the North and the South, a lot of cities and states were putting together decoration or memorial days where they would recognize the fallen soldiers. And it wasn't until actually 1966 where President Lyndon B. Johnson designated an official birthplace of the holiday by signing the presidential proclamation naming Waterloo, New York as the holder of the title of the originator of Memorial Day. And then also what they did is they turned it so there was going to be the last Monday of May. And the interesting thing is the holiday from latest to earliest is slightly more likely to fall on May 30th, May 28th, or May 25th than on May 27th or May 26th, and slightly less likely to occur on May 31st or May 29th for those statisticians out there. But Memorial Day is an important event to recognize our fallen soldiers, fallen veterans. And it's something that, as part of my work, we do a lot of work. I am a VA-accredited attorney. So one of the things that we do in our office is we help veterans and surviving spouses qualify for something called the non-service-connected pension, which is a way to help pay for home care or assisted living or even nursing home care for veterans and surviving spouses of veterans. So this is an important holiday. It's more than just a longer weekend. So I think it's important to start the show off this week just talking about the history of Memorial Day and why it's so important. And just like every show that we do, I always like to start with a positive focus, something positive that happened in the last week, either personally or professionally. I think it's a great way to start off any type of a show. I start off dinners with my family. We do a positive focus where my wife Rochelle or my son Ryan or Maddie will go right along around the table just sharing something that's happened in the day that was positive for us. So for me, this last week, my positive focus was that the Area Agency on Aging 1B, which helps a lot of seniors in the Metro Detroit area, they reached out to me and they're going to feature myself in an article called Ask the Expert. So it's going to be in their monthly newspaper that goes out. It's called Access. So I'm going to be featured most likely in the September article or September edition of the Access for the Area Agency on Aging 1B. And we're a big supporter of the Area Agency on Aging because each year they do a huge, probably the largest event that I've ever been to, the largest Caregiver Expo. And there's a lot of Caregiver Expos that go on. In fact, we just had a Caregiver Expo in Brighton this last week. They had a pretty good turnout, even though the weather wasn't really cooperating. So the Area Agency on Aging, they have a huge Caregiver Expo every October, usually right around the U of M MSU football game. It usually falls around that Saturday. But every October, where I think last year there might have been 3,000 people moving through the expo and probably 100 different vendors and supporters. Anyways, it's a great resource, and we're big supporters of the Area Agency on Aging, which also they handle Meals on Wheels and a lot of other services for Metro Detroit seniors. But anyways, they actually reached out to me and they're going to feature me in Ask the Expert. And the writer of the article, she sent over a couple questions that I think it would be interesting to share the questions and then share my answers to the loyal listeners of the Chris Berry Show. So the first question she asked is that I've used services of a family attorney for years. What is an elder law attorney? What would be the benefit of seeking services of a certified elder law attorney now that my husband and I are turning 65? Well, it's important to understand the distinction between just an attorney that dabbles in estate planning or elder law versus a certified elder law attorney. So a certified elder law attorney is thought of as the gold standard when it comes to estate planning and elder law, where we have to be peer reviewed. We have to, from there, we have the opportunity to sit down and take a 6-hour exam. And once you take a bar exam, you never want to take another exam ever again in your life. So the 6-hour certified elder law attorney exam, or the CELA exam, it's not a fun test to take. I think the last stat I heard is that only 16% of the attorneys that took the exam actually passed it. So when you're dealing with a certified elder law attorney, you know you're dealing with cream of the crop. And so also in my response to her, I wanted to differentiate what exactly elder law was from estate planning. So think of estate planning as planning for what happens if you die. Elder law, on the other hand, is planning for what happens if you don't. You continue to live and you face all the issues that go along with living. And I think that's actually the harder part. Anyone can plan where your stuff goes when you die and make sure you avoid probate, but what happens if you live? And what happens if you start to face the devastating cost of long-term care? And that's where a certified elder law attorney comes into play. Another question she asked, why did I become an elder law attorney? So what was kind of my backstory? Well, I started off doing estate planning. So estate planning, again, is planning for what happens if you pass away. But what was happening is my clients, they weren't calling me to say that mom passed away. They're calling me because mom fell, broke her hip, and was now going into a nursing home that costed $10,000 a month. And what could they do? And so I couldn't answer with, I don't know. So I dove deep into elder law, becoming as knowledgeable as I could to be able to provide services and have an answer to that question. So I think it's an important area of law. Another question she had here is what are the areas of expertise in elder law, and why did you choose to specialize in these areas? Well, it's the things we talk about on the Chris Berry Show. So things like planning for retirement, making sure money lasts as long as possible, avoiding probate, how to avoid paying unnecessary taxes, how to protect against devastating costs of long-term care. These are all things that are important pieces of the elder law puzzle. And one of the reasons I got into this area of law is that it's just helping good families plan and protect and preserve their quality of life. It's a very rewarding area of practice. In fact, just yesterday, I was walking out of the office, or the other day I was walking out of the office and ran into one of my clients who's become really good friends. We end up seeing each other pretty regularly. We did some planning for his mom, and we're talking about where they were going to dinner later. It's just a rewarding area of law where you're helping good families plan and protect and preserve what's important to them. One of our other questions here is, what questions should a person ask when seeking the services of an elder law attorney? So choosing a lawyer, choosing a financial planner, it's difficult because it's not like you're buying a car. You can't feel it. You can kind of shake my hand and whatnot, but you can't kick the tires, so to speak. And law and financial planning and tax planning, it's hard to visualize. It's hard to tell good from bad. And so that's why a lot of times distinctions such as a certified elder law attorney or a CFP are designations that you can look to where they've been peer reviewed. So it's not just, okay, who can I get a referral from or who can I find on the internet? It's important that your professional really has the knowledge that you seek. So if you're looking for an elder law attorney, then I'd suggest you find a certified elder law attorney. And you can find them throughout the United States, actually, by going to the National Elder Law Foundation organization. So that's one way to find a elder law attorney. And then the last question she had is, as the author of the Caregiver's Legal Guide to Planning for a Loved One with Chronic Illness, what was one of your goals in writing the book? And And so I have written a book back in 2014. I wrote a book called The Caregiver's Legal Guide to Caring for a Loved One with Chronic Illness, which you can get some more information on our website if you go to thechrisberryshow.com. But the book, you can actually get it on Amazon for about $15. And so one of my main purposes of writing that book is also one of my main purposes of putting together this show is that we want to get this information out there. There's a lot of misinformation and bad information. You can find whatever you want on the internet, but my goal is to really provide an education to the public, to my listeners, to the readers of the book, as well as to our clients. And I think a big part of that was just the way I was brought up. My dad, he was a professor for, I think, about 47 years at Oakland Community College. So I think that teaching, that role of an educator is something that's just innately in my blood. And so we do weekly workshops for clients and potential clients, and that's great, but we can only fit about 20 people into our workshop space at a time. And so with the book, I wanted to get this knowledge in more people's hands. How can we plan for the second half of life? And similarly with the radio show, I want to be able to touch more people with this information because it's important. And a lot of people are moving into that second half of life without really having the best plan possible. Plan to make sure that your money lasts as long as you do. And so with the book, with the radio show, it's really about sharing my knowledge, sharing that education. And when I'm meeting with clients one-on-one, it's helpful and I can dive into their situation. But I want to be able to help more people. And that's really the mission, my mission, the mission of our firm, the points of this radio show. And that was the purpose for writing that book, is to really share this information. Because again, there's a lot of misinformation. There's a lot of people that just don't have the deep level of knowledge that's necessary in planning for the second half of life. So that's why it's important to work with an expert, and that's why we want to get this information out there. So with that, this is Chris Berry. You're listening to The Chris Berry Show, where we talk legal, financial, and tax planning every Sunday at 2 p.m. on FM 101.5, AM 1400, The Patriot. You can ask us a question at any time by calling 810-355-2584, or feel free to email us at any time at askchris@thechrisberryshow.com. And in our third segment today, we'll get to some of those listeners' questions. I have a good number of questions to review. And then in the second segment, what we're going to do is we're going to talk about protection from the government. So one of the things that a lot of people find is that they don't want to rely on the government. They want to create their own rule book. So the government has a set of rules for you, and it's up to you whether you want to rely on the government or create your own rule book, so to speak. And we'll talk about things like probate, how to avoid probate while alive, as well as how to avoid probate upon death. And then also we're going to get into a discussion regarding taxes. So what are ways that we can minimize some of the big taxes out there? For example, the estate tax, the death tax, or the inheritance tax. What about gift taxes? And then what about income tax? What are the things that we can do to try to minimize the effect income tax has on those large tax-deferred accounts that we have, things like 401ks and IRAs? Because most people would rather spend their money than have the government spend their money. And so what are the things we can do to try to make sure that you're not giving all your money to Uncle Sam? So we're going to talk about that in the next segment. And then in the upcoming weeks, one of the things I'm very excited to bring to you is we're going to have a special guest. So we're going to have Maggie Gibbons, who works for the Alzheimer's Association. And she's going to share about the work that the Alzheimer's Association is doing to help fight Alzheimer's, as well as build and support services for caregivers and people suffering from Alzheimer's. Alzheimer's is something that's a very important cause for us at our firm. Each year we raise tens of thousands of dollars to help fight Alzheimer's. So Next couple of weeks, we'll have Maggie on, sharing her story and why we need to be thinking about Alzheimer's, which is something that affects a lot of my clients in terms of the second half of life. And there's certain things that we can do where if we do have a diagnosis of Alzheimer's, there's certain things that we need to put in place. One of those being things like a financial and medical power of attorney. So those are documents where if you were diagnosed with Alzheimer's or if you were to get a knock in your head, who's going to make financial and medical decisions for you? And that really needs to be mapped out, and that needs to be in writing because otherwise you're going to be looking at a trip to court to be able to handle things for a loved one. And we know that we want to keep things out of court. Again, we want to have our own rule book versus relying on the government's rule book. So look for Maggie to join us in the next couple of weeks. I'm very excited about that. So with that, again, this is Chris Berry, host of The Chris Berry Show, where we talk about legal, financial, and tax planning for the second half of life. Please stay with us into the next segment where we're going to talk about creating your own rule book versus relying on the government's rule book. So we're going to talk about avoiding probate while you're alive as well as when you pass away. Plus, we're going to talk about how to make sure that as much of your money stays in your pocket versus giving it to Uncle Sam. So we're going to have some strategies and ways that you can try to ensure that you're following your own rules versus relying on the government's rule book. And again, if you're listening to this on podcast, if you're listening to it on Memorial Day, just take a moment and think about what Memorial Day truly means. It's not just a day to enjoy a barbecue or the start of summer. It's a day that our veterans and we need to respect them. So with that, this is Chris Berry. Please join me after the break as we get into protecting ourselves from government, from probate, from unnecessary taxes. Thank you.
The cost of long-term care can be overwhelming. If you're dealing with long-term care costs, make plans to attend the next free informative workshop from the Elder Care Firm in Brighton. They'll show you how to protect your hard-earned assets and obtain the governmental benefits you deserve, including veterans benefits and Medicaid.
Hello, I'm attorney Chris Berry. As the only certified elder law attorney in Livingston County, I have the knowledge and estate planning strategies to help you. When you call, reserve your seat at our next workshop or schedule a free 15-minute phone consultation. The Elder Care Firm is here to help you and your family find solutions. Call us today.
Spots are filling up for the next free Elder Care Firm workshop. Reserve your seat today by calling 810-214-3800 or visit theeldercarefirm.com. The Elder Care Firm also invites you to join them at this year's Walk to End Alzheimer's. The walk is on Saturday, October 1st in downtown Brighton. Call 810-214-3800 today.
Welcome back to the Chris Berry Show. This is Chris Berry, where we talk legal, financial, and tax planning for the second half of life. Last week, we talked about 10 estate planning mistakes. So we wrapped up those 10 gruesome estate planning mistakes that we see people make in our office. Now, this week, what we're going to do is we're going to talk about creating a rule book, your own rule book, versus relying on the government's rule book. So you need to understand that the government has a set of rules for you, whether you like it or not. And they have a set of rules for you while you're alive, as well as if you were to pass away. And most people are familiar with the government's rule book upon death, and that's called probate. And most people want to avoid probate upon death because it's time-consuming. By statute in Michigan, it takes at least 5 months for assets to go through the probate process. It's costly. 3 to 5% of any assets get eaten up in costs, and those might be inventory fees, filing fees, publication fees, sometimes attorney fees. And also it's public. Anyone can see what's going through the probate process. So if you have a will that says you're leaving $100,000 to little Johnny, well, everyone knows that little Johnny has $100,000 coming to him. So we know that we want to avoid probate upon death. But people are sometimes surprised that you can end up in probate court while you're alive. And you might be asking, well, how does that happen? How does that work, Chris? Well, here's a situation. Let's say you're in a car accident or you received a knock on your head and you're unable to make your own decisions. Then someone needs to petition the court to become your guardian or conservator. So they have to petition the court to have legal authority to make decisions with regards to your care if you've never done a power of attorney. So they would petition the court to become your guardian, and now they can make decisions with regards to your care. And then if you happen to have money, not only are they going to make decisions, or not only are they going to appoint someone to make decisions with regards to your care, the guardianship, but now also they're going to appoint a conservator. So a conservator is someone that makes decisions with regards to your money, if you happen to have some. In both of these situations, the person who the court appoints might be your loved one who petitioned the court, or the court could also appoint an attorney who might have 250 other wards of the state that they're the guardian or conservator for. So the key thing to remember is that by leaving it up to the courts are going to be the ones making that final decision. So let's say that they have appointed you as the guardian or conservator. You still have to run major decisions past a judge, past the courts. So really it's taking control out of your hands and putting it in the government's hands. And so what we're going to talk about this segment is taking control, not leaving it up to the government. So how do we avoid those guardianships and conservatorships? Very simply, by putting together financial powers of attorney. So I'm going to mention two key documents to avoid the guardianships and the conservatorships. The first key document is a financial power of attorney, a financial power of attorney. And it's a document that appoints someone to make financial decisions for you. So who's going to pay your bills? Who has the authority to write checks? And if you're married, chances are you'd appoint your spouse first. And then if you have children, maybe you appoint your children in some order. So that would be appointing someone to make financial decisions for you. And by doing so, you're going to avoid the conservatorships. And then what about the guardianships? And what about decisions with regard to your care? Well, that's going to be a medical power of attorney. So the second key document to avoid that living probate is a medical power of attorney. And that medical power of attorney is a document that appoints someone to make medical decisions if you're unable to. And included in that would be decisions with regards to end of life. For example, maybe you've heard of Terri Schiavo. She was a woman down in Florida. She was in a vegetative state. Her husband wanted to remove her from life support, and her family wanted her to remain on life support. And it became a big court battle that lasted over 8 years. Well, if Terri Schiavo had had that medical power of attorney outlining what her end-of-life wishes were, then it wouldn't have been a big court battle that lasted 8 years. And there's some key takeaways from that Terri Schiavo situation. First of all, how old was Terri Schiavo? Do you know? Well, she was actually in her mid-30s. And what that tells us is that you never know when life is going to throw you a curveball. So anyone over the age 18 should have a financial and medical power of attorney. And then the second key takeaway from that Terri Schiavo situation was that just because she was married, that didn't automatically give her spouse the ability to remove her from life support. Her decision needs to be in writing. Similarly, in Michigan, the Michigan law states that it has to be clear and concise and in writing. So Terri Schiavo should have had a medical power of attorney appointing her spouse, if that was her decision, to be able to make medical decisions, including the decision with regards to end-of-life care. All of that could have been avoided had Terri Schiavo had that medical power of attorney. So if we're looking at avoiding the government's living probate while we're alive, avoiding the guardianships and conservatorships, taking control of your situation versus leaving it up to the government to decide your fate, then you're going to want to have a financial and medical power of attorney. That's how we avoid probate while we're alive. And how do we avoid probate upon death? How do we avoid that probate that we typically think of when we say the word probate? Well, we need to understand how estate administration works. And so estate administration, or the process of getting assets out of your name, really takes one of four forms. Okay, so there's 4 ways that assets can get out of your name when you pass away. And by understanding how assets are transferred upon death, you'll understand how we can avoid probate upon death. So first, we have joint ownership. So joint ownership is a great way for a married couple to transfer assets. So if we have husband and wife join on a checking account, husband passes away, then it's going to go to the wife. Very straightforward. The second way is through beneficiary designations. Beneficiary designations are things like life insurance or your 401k or IRA. You have to name a beneficiary so that when you pass away, it goes to whoever you've named. Very straightforward. Third, we have trusts. And we have different types of trusts. We have living trusts, we have castle trusts, we have veterans asset protection trusts. Think of a trust kind of like a suitcase. We put the assets into the suitcase, and then when you pass that suitcase on to your successor trustee, who then administers the trust for the benefit of the beneficiaries. So a trust is a great way to avoid probate. But if an asset doesn't pass through joint ownership, beneficiary designation trust, then it ends up going into probate. And now we have that court process that takes at least 5 months. It's costly. 3 to 5% of any assets typically get eaten up in probate. And also it's public. Anyone can see what's going through the probate process. So if we want to avoid probate, then we need to rely, or probate upon death, then we need to rely on one of those first 3 ways: joint ownership, beneficiary designation, or trust. Now, what's one thing that I didn't mention? A lot of people would expect to hear me talking about a will or a last will and testament. Well, unfortunately, all that a will does is gives instructions probate court on how to administer your estate. So if you're looking at avoiding probate and you're relying on a will to direct where your assets will go upon death, understand you're sending your loved ones to the probate court. So again, if you want to avoid probate, don't rely on a will-based estate plan. Instead, joint ownership, beneficiary designations, or trusts are the way to avoid probate. And of those, a lot of times a trust makes the most sense, but every situation is unique. So that's how we avoid probate while we're alive, probate upon death. That's how we keep the government from meddling in our affairs. Now, let's kind of switch gear and talk about our pocketbook. So we're going to talk about taxes. And we have a variety of different taxes, but I'm going to focus on 3 major types. First, I'm going to talk about estate taxes, then gift taxes, and then income tax, specifically as it relates to your IRAs and 401ks. So we have taxes. And the first tax I'm going to talk about is the estate tax, or the death tax, or the inheritance tax. They all basically mean the same thing. And the way it works is when you make money, you have to pay income tax, right? Well, when you pass away, the government takes another swipe of your assets, unfortunately. Now, they've been nice enough to give us an exemption amount or a coupon, meaning as long as we pass away with less than that exemption amount, we don't owe any estate tax. So they've been nice enough to give us a coupon, okay? So what is that exemption amount? Well, it used to be $600,000. And what that would mean is that if you passed away with, say, a life insurance policy of $1 million, and there's a $600,000 exemption, then what that means is $400,000 of that could get taxed up to 45%. So think about that tax. And it's a second tax. You were already taxed when you made the money. Now you're going to be taxed when you pass away as well. Well, that exemption amount, it's been going up steadily as part of the law. So it went up to $1 million, and then $3.5 million, then $5 million. And then Trump, as part of his tax plan, he actually just doubled it. So basically, as long as you pass away with less than $11 million, you don't owe any estate tax. So that estate tax exemption amount or that coupon amount is $11 million. Okay? So it's not really going to affect a lot of people unless you happen to win the Powerball recently. So for a majority of people, the estate tax, really not that big of an issue. Now let's talk about gift taxes. So in addition to the estate tax, we also have this gift tax. And the gift tax can be a little bit confusing, but once you understand it, it's pretty straightforward. So the way the gift tax works is if I were to give you money, you don't pay any tax on the money that you receive. You don't pay tax on the money you receive as a gift. However, what the government has said is that when you give money, you're actually taxed. Okay, so if I'm the one giving you money, I'm going to be the one paying the tax. And so the way the gift tax works is there's an annual exemption amount. meaning I can gift to as many individuals as I want as long as the amount I gift to that individual is less than the exemption amount. And a lot of people think that number is about $10,000. Well, it's been adjusted, and with the Trump tax plan, now that exemption amount is $15,000. Meaning, I could give $15,000 to my son, Ryan. He'd spend all the money on Legos, which I think would be pretty cool. But he wouldn't owe any tax, and I wouldn't owe any tax. And also understand it's not just a total of $15,000. I can give $15,000 to as many people as I want. So if I wanted to give $15,000 to my daughter, Madison, she'd spend it all on princess clothes as she's planning her royal wedding with all the royal wedding news going around. But I would still owe zero gift tax. And she would also owe zero gift tax because when you receive a gift, you don't owe any gift taxes. Now, gifting is great, but what happens if you gift more than that $15,000? Do you owe any gift tax? And the answer is probably not, because the gift tax is also tied to the estate tax. So you have an annual gift tax exclusion amount of $11 million. So as long as you're not driving, raise your hand if you're gifting more than $11 million during your lifetime. I'm doubting many hands went up. So for a majority of people, gift taxes really aren't a concern. Now, that said, I'm not a big fan of gifting. And the reason why is because while you can gift for gift tax purposes, you cannot for Medicaid purposes. And we haven't talked about Medicaid today on the show, but it's a governmental program that will pay nursing home costs. But they look back 5 years to see if you've moved or gifted any money around. And while you can gift for gift tax purposes, you can't for Medicaid because they'll look back and they'll potentially penalize you. So if there's a concern of long-term care in the near future, you need to be very careful in making gifts. And then the third tax that I'm going to talk about, and I'm going to start talking about it now, and we'll finish up in the next segment, is the income tax, specifically as it relates to IRAs. So the income tax, think of it, marginal tax rates. Think of marginal tax rates kind of like a graduated cylinder. As you make money, you pour it into the cylinder and you pay a higher marginal tax rate. And that income could be from salary, that could be from required minimum distributions, that could be from pensions. So as you pour money into your marginal tax rate, that graduated cylinder, the more money you make, the higher the percentage that you're going to pay. So in the next segment, we're going to talk more about marginal tax rates, income tax, and things we can do to try to keep more dollars in your pocket versus giving it to Uncle Sam. So join me in the next segment. And you're listening to Chris Berry, host of The Chris Berry Show, where we talk legal, financial, and tax planning for the second half of life. Also, in the next segment, we're going to read some questions, and I'm going to answer some of the questions we've had listeners submit. So if you do have a legal, financial, or tax question that you want to answer to, call our office at 810-355-2584, or you can visit us online at thechrisberryshow.com, where you can also sign up for one of our weekly workshops that we have in throughout Metro Detroit at our Livonia, Novi, Bloomfield Hills, or Brighton offices. And we do these workshops about once a week to really educate the public on topics that we talk about here on The Chris Berry Show, where we talk legal, financial, and tax planning for the second half of life every Sunday at 2 p.m. on AM 1400, The Patriot, and you can listen to us on FM 101.5. And then also you can listen to us via podcast through iTunes or at going to our website, thechrisberryshow.com. So join us in our next segment as we talk more about income tax.
If you or a loved one is facing long-term care costs, make sure you talk with certified elder law attorney Chris Berry from the Elder Care Firm. He can help you, like he did Keith Gerard's family. Here's Keith.
Basically, it's my in-laws. They're both 90, and they can't live on their own or anything, and they don't have enough money to go in assisted living. We went to Chris Berry to get the VA benefits, and he said, well, we can get almost $2,000 a month, which they can put towards assisted living. It was a big relief. Most lawyers are pretty sharp, but Chris, he knows exactly his business, and it's a shame that these vets have to go through all these processes, but I guess we need people like Chris to help us out. He made it so easy for us.
Hello, I'm attorney Chris Berry. The elder care firm is here to help you and your family find solutions. Call us today.
Get the governmental benefits you deserve. The Elder Care Firm is ready to help you. Visit theeldercarefirm.com today or call 810-214-3800.
Welcome back to the Chris Berry Show. This is your host, Chris Berry, where we talk legal, financial, and tax planning for the second half of life. This segment, we're going to wrap up talking about protecting ourselves from paying too much in terms of taxes. Then I'm going to get to answering some of your questions that you've submitted through either the email or the phone number. So if you do have questions, feel free to email us at askchris@thechrisberryshow.com, or feel free to call 810-355-2584, where you can leave us a question that we'll answer on air if we get a chance. Or you can also go to our website, thechrisberryshow.com, where you can see a list of our upcoming workshops, weekly workshops, as well as a spot where you can leave questions that we'll answer. So I was talking about taxes, and we're talking about estate taxes, gift taxes, and now we're going to talk about income tax as it relates to your tax-deferred accounts, your IRAs, your 401ks. And so I'd like to start off first with a definition, and a definition of marginal tax rates. So that's the amount of tax that you pay on your income. And it's like a graduated cylinder where as you pour more income on that, you're going to pay more tax. And it starts out at 0 and then goes to 10 and then 12%, then jumps up to 22% and 24% and onward. So as you make more money, you pay more income tax, pay a higher percentage. So with that definition, now I'm going to ask you a question and then plant a seed in your head. So the question is, 10 years from today, do you think marginal tax rates are going to be higher or lower than they are now? So 10 years from today, do you think across the board the marginal tax rates are going to be higher or lower? Well, most experts think higher, and there's a couple reasons for this. First of all is the amount of national debt that the United States has. This year we just passed $21 trillion in debt. So $21 trillion, that's how much in debt we are. I can't even imagine the cost of that debt. So we're $21 trillion in debt. Now, the second thing is that in addition to that debt, we have all these baby boomers retiring, so less taxes coming in. And then a big part of it is that we're at one of the historically lowest marginal tax rates in history. So we're at one of the historically lowest marginal tax rates in history. For example, if I were to ask you, have you heard of Ronald Reagan? Most people would raise their hand at that. And if I were to ask you, do you know what Ronald Reagan used to do before he was a politician? Most people would answer with that he was an actor, right? So can you guess what the highest marginal tax rate was when Ronald Reagan was an actor? And I'll give you a second to think about it, or Google it. But the answer is 94%. So when Ronald Reagan was an actor in the 40s, we had the highest marginal tax rate of 94%. And then the question is, well, where did that remaining 6% go, right? And some people might be saying Nancy, but the true answer is it went to the state. So effectively, if Ronald Reagan made 2 movies, made $200,000, he would be at the highest marginal tax rate, and he'd be paying 100% income tax, meaning $100 of every $100 would go to the government, and he would see 0. So he'd be effectively retired after making 2 movies in a year. So what was going on during the 40s? Conflict, right? We're in World War II. And if you look historically at the highest marginal tax rates in history, they have always been during periods of conflict. So World War II, Korea, Vietnam. Well, guess what? We've been in conflict since the 90s, right? So if you add up all of these different factors, a lot of people think that taxes are going to go up in the future. So if that's the case, then this is the seed I'm going to plant. And this might be a topic for a whole show coming up. But if that's the case, if we can agree that taxes are going to go up in the future, why do we defer paying taxes as long as possible? So why do we have large tax-deferred accounts? If we think taxes are going to go up in the future, doesn't it make sense to pay the tax now versus later? Doesn't it make sense to pay the tax on the seed versus the harvest? Well, imagine you're a farmer. Do you want to pay tax on your harvest, or do you want to pay tax on the seed? So why do we continue to defer paying taxes as long as possible? And there's a lot of reasons why, but that's the seed I want to plant in your head, because based on how we answer that question, we can look at different ways of paying tax. So if we're comfortable thinking about paying taxes now versus later, then overall we might pay less tax. Because if you look at your IRAs, which are pre-tax dollars, if you look at your 401ks, which are pre-tax dollars, meaning you haven't paid any income tax on it, you don't have that full amount that's in that account. You're in partnership with Uncle Sam. And think of it kind of like a mortgage, right? So if you have a $300 or $300,000 home and you have a $200,000 mortgage, how much do you really have? You have $100,000. Now, how many of you out there are homeowners and you have a fixed mortgage, right? Most people shy away from those adjustable rate mortgages. But if you look at your IRAs and 401ks, you basically have an adjustable rate mortgage on that account. And President Trump has just lowered that mortgage for you. And if we think, and even the way the law is written, it is scheduled to go back to pre-Trump levels. So look at it as adjustable rate mortgage, and they just lowered that mortgage. Doesn't it make sense to get out of the partnership with the U.S. government sooner rather than later? And that has a drastic effect on retirement. That has a drastic effect on estate planning, leaving those accounts to the next generation. It just drives a lot of interesting questions if you just ask yourself, why do I continue to defer paying taxes as long as possible? And so one of the strategies is to maybe look at intentionally and strategically over the next couple of years, next 5 to 8 years, paying the income tax over time. And that's where we get into, we call it bucket bracket bumping, where we look at how much in that marginal tax rate do you have to move before you jump up into a higher tax bracket. And it's one of the things that we do in our office. And in fact, this past week, we did actually 4 workshops. So we did 2 legal workshops as well as 2 workshops on this concept of a tax-efficient retirement. So if you want some more information on those workshops, you can go to thechrisberryshow.com. That has a list of our upcoming workshops. Or you can give us a call at 810-355-2584 if you want to ask us any questions that we'll take care of on the Chris Berry Show. And that's what we're going to get into next, is some of our listeners' questions. And so the first question we have is from Alex. And Alex writes in that I have a power of attorney for my dad who has mild dementia and easily confused. His second wife is not trusted to act in his best interests. Can she have him sign a new power of attorney without my knowledge? This is an interesting question from Alex. So I'm guessing Alex's dad had a financial and medical power of attorney that, like we talked about earlier, avoids the living probate. So Alex's dad created that rule book so he didn't have to rely on the government's rule book, didn't have to rely on going to court. And so his dad took a good first step there. But now it sounds like we're in an interesting kind of family dynamic where Alex feels like dad's second wife shouldn't be trusted. And it's an interesting thing that we see quite often in our office. And we talk about this at our workshops of what happens when a second spouse comes into play. And there's some things that Alex's dad could do ahead of time in terms of trust planning. But getting to Alex's question of, can she have him sign a new power of attorney without my knowledge? Unfortunately, the answer is yes. If you are named as a power of attorney and someone changes that power of attorney, there's no duty, there's no notice to that currently acting power of attorney, which can be sometimes a little bit odd. Now, another piece of this question is that dad has mild dementia. And so with that mild dementia, question that I don't have an answer to based on this situation is, does Dad still have capacity to sign a new power of attorney? So in Michigan, to be able to sign a power of attorney, you have to have what's called lucid moments, where you have to understand the nature of what you're doing. So, Alex, yes, your dad can sign a power of attorney without your notice. Whether that power of attorney would be legal or not is another question on whether Dad actually has capacity to sign. So I wish you luck. So our second question here. Should the tax rate on a 401k withdrawal be lower after reaching age 59 and a half? And this question is from Matt. So my spouse and I paid a 20% tax on an early distribution from a 401k and now have reached 59 and a half. Upon withdrawal, should the tax bill be lower due to there being no penalty? I've been told it still would be 20%. So I think we just need to clarify this question a little bit. So what Matt is saying is that he took out, prior to 59 and a half, he took out of his 401k, his pre-tax account. And that's something that's unique with these qualified accounts, 401ks and IRAs, is that basically the government will penalize you if you take the money out of it incorrectly. So one of the features of these accounts is that if you take the money out, unless you have an exception prior to 59 and a half, chances are you're going to pay a penalty on that. Likewise, if you fail to take out your required minimum distributions once you reach age 70 and a half, likewise, you're also going to have a huge penalty. Okay. Now, there's two pieces to it. One part is the penalty for taking it out too early or taking it out too late. But then you also have the tax. And the way the tax works is it's additional income. So what you would have to do, Matt, is look at what your marginal tax rate is without taking money out of the qualified account. So what is your salary, your pension? What is that amount? And then as you take money out of the qualified accounts, that's just going to pour more income, which could potentially raise your marginal tax rate. Which, keep in mind, your marginal tax rate, it is not your effective tax rate. Your effective tax rate would be the amount of tax you actually paid. The marginal tax rate is just the top level of that graduated cylinder that you hit. So to answer your question, Matt, your income tax is going to be not based on your age. Your income tax is actually going to be based on your marginal tax rate. Now that you are 59 and a half, what you and your wife are avoiding is the penalty. So now you can take that money out penalty free, but you are still going to have to pay tax, and it's just going to be based on your marginal tax rate. So thanks for that one, Matt. Next, we have Donald. And Donald asks, my mother and father have both died, but they were divorced. During the divorce, she was awarded half his pension. I'm trying to see if I can get the pension, and do I have to split it with my siblings, being that we have different fathers, and it's my father's pension. So Donald asks a question about a pension. And a pension, it really isn't an asset. Now, you have the opportunity while you're working to do a lump sum buyout of that pension, where now that pension will roll out into an IRA and be pre-tax. So there will be an asset there. But if it's a strict pension, it's similar to Social Security in the sense that it's not something that we can leave to children. You can leave it to a spouse, or a portion of it can go to a spouse, but it's not an asset that we can leave to children through a trust or any type of estate administration typically. So I think in this situation, basically what's going to happen with father is that when he passes away, similar to how his Social Security will end and not go to the children, the same effect is going to happen with his pension. So unfortunately, it's not something that you can split between your siblings. Donald's father's pension passes away when Donald does. So I hope that helped clarify things. This next question, how do we handle a ladybird deed when the owner can no longer make decisions? She has dementia, apparently. And this is Joseph, and he says, I have power of attorney for my mother's estate. She set up a ladybird deed that has myself and my siblings listed on the deed. So in this situation, Joseph's mother looks like she set up a ladybird deed. So a ladybird deed is a document or a type of deed like a quitclaim deed or a warranty deed that says it's in your name while you're alive, and then if you were to pass away, then it avoids probate and goes to whoever we've named as a beneficiary. So it's like a beneficiary designation for your home, and it's a much better alternative than we call it the deed in the drawer trick, where you sign a deed but you don't record it. This is something that's recorded, it's on the up and up, and it's not in that gray area of the deed in the drawer trick where you sign a deed but don't record it. So he asks, how do we handle the ladybird deed when the owner can no longer make decisions with regards to dementia? Well, I'm not sure if there's that much to handle because once it's set up, it's basically taken care of, recorded. The one thing I'd suggest to Joseph is that you make sure that we have a power of attorney in place, assuming Mom still has those lucid moments, similar to Alex's question. So with that, those were some of the top questions submitted over the past week. If you do have a question that you would like us to answer, feel free to call us at 810-355-2584 to leave that question. We'll try to get to answering it on air. And again, this is Chris Berry, host of The Chris Berry Show, and where you can listen to us on FM 101.5, AM 1400, The Patriot, every Sunday at 2 o'clock, or you can listen to us on iTunes. And I want to say it's been great. I hope you have a great Memorial Day tomorrow. And join us next week. Next week, we're going to talk about the elder care continuum, the elder care journey. And I want to leave you with a quote, if you can dream it, you can do it, by one of my favorites, Walt Disney. And last, I just want to say thank you. Make it a great week. Happy Memorial Day.
Learn more about Chris Berry and the Elder Care Firm by visiting online at MichiganEstatePlanning.com. That's MichiganEstatePlanning.com. You can also call Chris Berry at 888-390-4360. 888-390-4360. This program content reflects the opinions of Chris Berry and his guests, not the Elder Care Firm, Prosperity Capital Advisors, or the C.J. Berry Group, and is subject to change at any time without notice. Content provided herein is for informational purposes only and should not be used or construed as investment or legal advice or a recommendation regarding the purchase or sale of any security or to follow any legal or tax strategy. There's no guarantee that the strategist's statements, opinions, or forecast provided herein will prove to be correct. Past performance is not a guarantee of future results. Indices are not available for direct investment. Any investor who attempts to mimic the performance of an index would incur fees and expenses, which would reduce returns. All investing involves risk, including the potential for loss of principal. There's no guarantee that any investment plan or strategy will be successful. We recommend that you consult with a professional dedicated to your needs. This program is furnished by the Elder Care Firm.
The cost of long-term care can be overwhelming. If you're dealing with long-term care costs, make plans to attend the next free informative workshop from the Elder Care Firm in Brighton. They'll show you how to protect your hard-earned assets and obtain the governmental benefits you deserve, including veterans benefits and Medicaid.
Hello, I'm attorney Chris Berry. As the only certified elder law attorney in Livingston County, I have the knowledge and estate planning strategies to help you. When you call, reserve your seat at our next workshop or schedule a free 15-minute phone consultation. The Elder Care Firm is here to help you and your family find solutions. Call us today.
Spots are filling up for the next free Elder Care Firm workshop. Reserve your seat today by calling 810-214-3800 or visit theeldercarefirm.com. The Elder Care Firm also invites you to join them for Excite Night at the Pound in downtown Brighton on Tuesday night, August 9th from 5 to 7. This is the kickoff event for this year's Walk to End Alzheimer's, coming up on October 1st. Call 810-214-3800 today.